Generally, a party commits the tort slander of title by publishing a false or malicious statement that disparages another's title to real or personal property. But can a party commit slander of title by filing notice of lis pendens that gives parties notice that certain pieces of real property are subject to pending litigation? The Georgia Court of Appeals considered this question in Executive Excellence versus Martin Brothers Investments. Executive Excellence, through Richard Fritts, owned a 15-acre tract of land in Georgia. At the same time, Sterling Trust owned a 4-acre tract of land for the Benefit of Fritts. In December of 2006, Fritts contracted to sell the tracts to Sund Enterprises, which assigned its rights in the 15-acre tract to Southern Tradition Investments and its rights in the 4-acre tract to Martin Brothers Investments. The contracts included a provision that made the sale contingent on the buyers persuading local governments to rezone the property. But when Southern and Martin's rezoning application wasn't approved by the specified deadline, Executive sent Southern a letter rescinding the contract. Sterling then sent Martin a letter advising that the purported contract was null and void because Sterling didn't approve it. Nevertheless, Southern and Martin continued to pursue rezoning, and at a board meeting, Southern and Martin's agent told third parties that they intended to pursue enforcement of the contracts to teach Fritts a lesson. Also, at a later board meeting, Southern and Martin's attorney stated that the properties could be tied up in litigation for the next 5 to 10 years. Subsequently, Southern and Martin sued Executive, Fritts, and Sterling Trust in state superior court and asserted claims for contract reformation, specific performance, and attorney's fees. At the same time, Southern and Martin filed notices of lis pendens. In response, Executive and others counterclaimed for slander of title, arguing that Southern and Martin maliciously impugned their title by filing notices of lis pendens and making the statements to third parties. After filing for a voluntary dismissal of their claims without prejudice, Southern and Martin moved for summary judgment on the counterclaims, which the court granted. The court later granted the parties attorney's fees. The parties appealed to the Georgia Court of Appeals.